guys. Let's talk about this Frank's hearing request by the defense in the Richard Allen case again, because the state has filed its response to that motion. And it's a little bit interesting how they approached it. So let's take some of the sensational aspects out of this. We already talked about that, and get into what legally are they asking for? What's the legal standard? What do they have to show? And whether one thinks they've done it or not. So let's get these slides up here. The defense says, and this is, I think, correct, that the defense is required to make a substantial preliminary showing that omitted or false statements were made knowingly or intentionally or with reckless disregard. Okay, so they have to do that first. And if the trial court concludes that these things that they say were omitted or lied about were necessary for the finding of probable cause, then the trial court sets the hearing to see whether this evidence potentially could be suppressed. It resulted from the search warrant of his car and his home. So you have to show that you've got intentional or reckless falsehoods or omissions, okay, that were necessary for probable cause. So it's not just one or the other. You have to have both. All right, so let's see how this works out. Now, the state has filed its objection, the second objection, because the defense had already filed a motion to destroy this search warrant, and the state objected to that in the first place. And now they have this new one for Frank's hearing for the alleged lies of law enforcement that would have caused the judge to issue a search warrant when the judge otherwise would not have. And the state says, you know, okay, you filed one back in May and now you're filing another one. They don't agree with it. Note they say at the bottom, once again, while the memorandum is colorful, dramatic, and highly unprofessional, it is not completely true. That's the state's characterization of the defense motion. However, unfortunately, the state doesn't really get into rebutting any of the things that the defense says. Rather, they cite the standards of the law, which is fine and you should, and say they've complied with it. I thought we'd see a little more, and maybe there will be more when they argue this in front of the judge if that occurs. Now, don't confuse a defense of the case by Allen's attorneys with a suppression motion, because obviously the Odin stuff, that just swamped everything. And a defense theory of some other dude did it, that's intriguing. I mean, it's interesting to me as well. But there's no requirement for a search warrant, okay, that police discuss every possible lead in theory or something that the defense down the line may think shows that their guy didn't do it. That's not the standard. The standard is probable cause, okay, probable cause for Richard Allen that he was connected to this crime, and they would find evidence of that if they executed the search warrant. They don't have to prove the crime ahead of time, or else what's the point of search warrants, right? So no. So a lot of that brief and the memorandum that they submitted was directed toward a lot of this Odin stuff and other people that they say did it, which is interesting, but it's not precisely what's at issue in the request. Now, on terms of this Odin stuff, I did see that the law enforcement officer, or one of them that they cite as an intrepid person with a lot of curiosity and search for the truth, kept pushing this idea that potentially the Odin people did it and there was a ritual killing, because that's the theory proffered in the defense memorandum. But look what he has said about that. No one in law enforcement believes Abby and Libby were killed in a ritual sacrifice. That is the defense twisting facts for sensationalism. Now, that's not in the record for opposition to this, but it does color, I think, how one would view what the defense is saying, because we can't see all the underlying documents. Well, one of the guys that they say supports their theory has now said this in public, that no one believes they were killed in a ritual sacrifice. Okay, so that's directly contrary to what they say in the memorandum. Now, whether the scene was ritual or not in nature, that can matter, obviously, to the mindset of the murderers, and it might show some motive. But that's not by itself excluding Allen, even if you accept their characterization of it. It could, and it could not. And the theory, at least, was downgraded by law enforcement, as the defense claims in their brief, although they cite Click as contrary to that. He said, no, I don't think that either. The defense part, a brief part about the Odin guards, that's got nothing to do with whether the search warrant was supported by probable cause, because they're saying these guards at this other place in this prison are pressuring him to confess and things. That's not related to whether there was probable cause for the search warrant. I mean, it's important to their case, but it's beyond the scope of what they're asking the judge to look at here. In fact, it's a shocking fact, as they say in their memo, and equates to the foxes watching the hen house. But what does it have to do with, at the time the search warrant was requested and granted by the judge, whether the affidavit that supports it was correct or not, or materially false in some important way. Nothing. Note, they do say it took, that the police should have known and did know and think that it took many men to conduct the crime. That's on page 69 of their memo. Okay. A little gender specific there. I guess they're saying women couldn't do this or whatever. And what's many? So now it's not just the bridge guy and maybe an accomplice, maybe not even a third guy. It's many people. This scene is so complicated that it takes like a group of people to do it. That's a theory. I don't think you have to present that theory to the judge that maybe a gang did it. Okay. No. And they do spend, I'm not going to name the guy, but they spend a lot of time in their brief discussing somebody who law enforcement apparently concluded, even according to the defense, had an alibi. And the defense doesn't agree with it, and that's fine too. But do you have to tell the judge that? Is it a lie to the judge or some kind of serious omission if you don't tell the judge in a search warrant for one person, hey, at various times in this case, we looked at tips involving 792 people, and 28 of those we looked into, and 5 of those we looked into a little bit more, and they had alibis and these reasons. The search warrant application is going to be like 78 pages long now. No, I don't think so. It is no way indicating that it's a lie told to the judge that they looked into somebody and decided the person had an alibi, even if they're wrong about that. Now, that can matter downstream in the case, of course, but we're talking about the search warrant application. And even they say, well, maybe that alibi is good, but maybe that person had their minions do it. Yeah. So if for a search warrant application, you're going to have to express all of these theories that ninjas and minions and stuff like that, and Odin people and cults and many men and stuff. You have to, no, that's not the search warrant standard. Now, they do have some things that matter, but I'm telling you, in my opinion, this Odin stuff is way outside the game here, at least as far as, and to the extent it was expressed in their memorandum. Now, more importantly, I think are the alleged timeline lies, because they're saying that this timeline that places Allen at the scene at the time the crime occurred, it's based on falsehoods told to the judge. Well, that certainly does matter, right? And I'm going to break that down to 3 parts: identification of a person on the bridge, identification of the vehicle at the CPS building, and identification of the person saw on the road after the crime occurred, or probably after the crime occurred. So for the person on the bridge, well, note in the alleged conspiracy of law enforcement lies, law enforcement did tell the judge about the teen girls' different descriptions of the guy on the trail that they saw, different types of clothes and things like that. If you're lying to generate a narrative and frame Richard Allen, why would you, and you're going to lie about what other people said, why would you put that in there? Because the judge could look at that and say, well, they didn't even see the same person. There's no reliability there. Now, of course, one reason is because you're really just trying to express the point that they saw a guy and Allen saw 3 girls. And that is important, particularly since the girls were there at about 1:30, and he's changed his story to say he was leaving at 1:30, but this guy was coming, which is consistent with his first recorded story, or the notes of that story. Now, on the other hand, though, and that's my point here, is like, if there's a conspiracy about law enforcement, it's not a very good one, because this whole narrative is not tightly wound to frame Allen. On the other hand, they didn't tell the judge that Allen said now that he was gone by 1:30. Should they have done that? Should they, if they're saying that the evidence, especially his first story, is that I was there between 1:30 and 3:30, should they then have at least told the judge, hey, but now he's saying I was gone at 1:30, but we don't think that's true because of the timestamp video and stuff like that they do have in there. Should they have told him that? That's potentially an admission. And if you had told the judge that, would the judge have said, well, if he's saying he was gone by 1:30 now, I'm not going to give you the warrant. So I think you could characterize it as an omission. I don't think it would change the judge's decision on whether there's a search warrant or not. That's my opinion, but that's the kind of thing the judge has to decide. So you may have a different position on that, right? Let's talk about it, some more of that. So in the affidavit for the search warrant, they say that Blair, the female witness who walked down to the bridge and turned around and left, and just before the crime occurred, was shown a picture of the man on the bridge and said, yeah, that's the same guy I saw, and described as a white male wearing blue jeans and a blue jean jacket. So if you see that picture of the guy on the bridge and you think that looks like Allen, then that is similar. And if you don't, then it's dissimilar. But in the motion, they say, listen, she's told various things. At one time, she said she thought he was about 20. At another time, shortly after that, 20s to 30s, had poofy hair. I don't remember any facial hair. Is not telling the judge that at some point she said he has poofy hair and I don't remember any facial hair. If the judge had heard that, would the judge say, well, then I'm not going to give you a warrant then? especially considering she was also shown a picture of the person on the bridge and said, yeah, that looks like that person. Okay, because all they're saying is that Alan was wearing things consistent with what the guy on the bridge wore, and she's saying the guy on the bridge that's the guy I saw. Is that close enough there? How does that mean? How would that mean that this excludes Alan? Now the defense is saying because he didn't have poofy hair and he didn't have facial hair, and if the judge had heard her say that, the judge would say, well, then there's no way this reconciles, and I will not issue a search warrant. Does that sound right to you with regard to the rest of the timeline, which includes the 3 girls seeing a guy coming, Alan saying he sees 3 girls, he sees nobody else, no poofy haired guy or anything like that while he's on the trail. Nobody else saw a poofy haired guy either. I don't know if this woman really saw a poofy haired guy or that's just what she recalled and it was part of the hood or hat or whatever. I can't say. That's certainly good points for the defense, but I think it's asking a lot to think that if only those words had been put into the search warrant application, the judge would have said, well, I'm not going to issue the search warrant. That seems doubtful to me, given that Alan set himself into the original statements there between 1:30 and 3:30, although he said something different years later. And you have the timestamp picture that the girls took around 1:30 where they see a guy coming. He sees 3 girls. That to me, I don't know how you talk yourself out of that's not him. That to me seems like that certainly is him. So I think the timeline is still supported there, whether there's, maybe the person had poofy hair and maybe they didn't. But again, to me, this is unlike the Odin stuff. This is on point. Did the police conceal from the judge things that a witness said that would cause a judge not to issue the search warrant or to find that there's no probable cause for the search warrant? Okay. I don't think so here. But again, that's a question you can ask yourself as long as we all understand the standard. What about the vehicle at the CPS building? Okay, this is a good one for defense. Blair noted, it says in the affidavit for the search warrant, a vehicle parked in an odd manner. And then another witness says they saw a purple PT Cruiser. Now, allegedly, Alan was driving a black Ford Focus. So the alleged material omission, the defense says, is Blair actually told the police she saw an old Comet and it wasn't black. Now, how she says these things, unfortunately, we can't see because a lot of these exhibits we can't see. So I'm taking it on face value that this is what she did tell the police at some point. So then in that case, that's a fair point, right? Because she saw a vehicle there is one thing, but if she tells you it's a vehicle that is not like Alan's, you can see the defense's point that that's potentially to the degree the vehicle is important and you're bothering to mention it at all as inculpatory towards Alan. If the rest of the description is, but it didn't look anything like his vehicle, that seems like an issue, like a material omission. Now, having said that, the next witness that they quote didn't see a black Ford Focus there. He saw what he said was a PT Cruiser that was purple. Well, that's not necessarily a PT Cruiser is kind of distinctive. Would you confuse that with a Ford Focus? I don't think so. So it is true that in the affidavit, there is a contrary description of the vehicle. And I don't think there's somebody saying, yeah, I saw the black Ford Focus at the building. So now you have the question of if the judge heard this and said, well, you didn't tell me that she thought it was an old Comet and not black, and I'm not going to issue the search warrant on the basis of the other things that I've heard because this changes my mind about it. If the judge would think, if I already have one witness saying the vehicle didn't match, but if I had this other witness also saying it, then I wouldn't give you the search warrant, then the state could have a problem. A little surprised they didn't address this type of thing in their response. But, I don't know how they practice, and there may be a good reason for that. And they may feel like they'll do it later if they need to or something like that. I don't know if the defense is totally correct in what they're saying Blair said, but I don't have anything from the state that tells me differently about this old Comet thing. So to me, this is one of the defense's better points because the state makes the car's presence at the old CPS building a material issue at the time the crime was committed. And they don't tell the judge that the witness didn't say, I don't remember what kind of car it was, but according to them, she said, no, I remember what kind of car it was. And it was this old Comet that was not black. And that's not what Alan drove. So then where was his vehicle at? Now it's possible his vehicle was somewhere else around the building and she did see a Comet and this guy did see a PT Cruiser and maybe his black vehicle somewhere else, but that's pure speculation, right? And if you want to do that, that's okay. But the idea is, should you have told the judge what the witness said here? I would have liked to have heard the state address that. How about the person on the road? Okay, so in the affidavit, the lady is quoted as saying that he was wearing a blue colored jacket and it was muddy and bloody. And also, it says that she was shown a picture of the man on the bridge and says, yeah, that's the same guy I saw. But in the motion, they say that the interview she did with the police, she only said in it that he wore a tan and light colored coat and never said it was bloody. So the color was wrong, and the bloody, they say, is complete fabrication. Is that true? And if that's true that they made this up, and I can't assess it because we don't have those records in front of us. If they made it up, that's, this stuff could be seen as material, not that it destroys the other evidence, but just that it's concealing another side to the evidence. And then it would come down to whether the judge would say, well, then I'm not going to issue a search warrant or not. Because certainly we don't know if this person that this woman saw was even connected to the crime for sure, just that they were leaving the scene just slightly before 4 o'clock, heading down the road toward, I shouldn't say leaving the scene. They're walking down the road close to 4 o'clock, headed toward the old CPS building. So that is listed as supportive of the state's case. So it is the state putting it at issue as being important. And then if they didn't tell material things about it, you can kind of see the defense's point on that. So, again, I think the state response, as I saw, and maybe there's more, sometimes things are filed under seal and you don't see it all, but it didn't really address these arguments that the defense brought out. And to me, the defense went way overboard in what they were doing. They should have cleaned this up to push to the judge. These are the 3 things that when you add them up, materially change the analysis of probable cause, and the judge would not have issued it, because you got to show that it was a material misrepresentation of fact or omission of fact, intentionally done or reckless, and it would have changed the analysis on probable cause. And they submit something that's 130 some pages long and has a lot of things in there like shocking facts and guards and Odin people all over the place and drawings and things. And that's maybe good, as I say, later on in their case, but you're asking the judge to invalidate a warrant, and it really needs to be about what was presented to the judge at that point and how it was factually, materially wrong at that point. And other theories and other people and stuff, you're not going to get the judge to say, you have to tell me your entire case file and all your thinking on it. But these specific things where the state does say, these are important items for the search warrant because we're the ones writing up this application, we mentioned them. If you only tell half the story, then you can see where the defense would be coming from. But I think, it's only a small part of this 130 some pages that they dwell on this. The Odin stuff is much more of it. And, here's the different sketches that they have issues with. And I think it's interesting because I'm not saying that Alan is any of these pictures, but I am saying it all depends on which pictures of him you pick, because the top one looks kind of like that, right? And the bottom ones look similar too. It looks a little bit like different people there, even though it's the same guy. So as law enforcement has said from the start, these sketches are of limited utility. They're kind of to ring a bell or something like that. But I don't think they necessarily show that it's different people any more than they necessarily show it's Alan, because you could drop a picture of a lot of guys next to those and they would be to some degree similar. So when I analyze it, those are the things that I think the defense actually has a real argument about. It's not just sensational stuff, that the state brought out particular things about the timeline, statements by witnesses and what they saw, but judge, they didn't tell you these things from the witnesses that it was showing you that it doesn't have the certainty that they presented. And then it comes down to the question of, would that be such that the judge would say, I wouldn't have issued the search warrant then. So let's come into this hearing and see whether this stuff is true or not. I think individually, no, I don't think it impacts the analysis. So I think if you're the defense, you'd have to argue, but collectively, when you look at all of these things together, you can see if you have to or choose to omit this many items out of your fact narrative, it indicates that your fact narrative is not good enough. One thing, okay. Another thing, maybe okay. Consistent across who the people are, that or what was seen on the bridge, to the person on the road, to the car, that all of those have things that are materially different than what the witnesses actually said. You would make your argument that this impacted the probable cause analysis. I don't think that it does, because it's just probable cause. So that's my opinion on it. But at least we've discussed the standard of it, right? And how it works. I think the judge, you could have written all those things in. Judges know that eyewitnesses have levels of uncertainty. So you have to look at the timestamps, the time frame of things, and go, yeah, there's a pretty good chance this was the guy, because this is only probable cause, right? So you can have a search warrant and check and see if you find evidence or not. And then the defense has to say, no, the judge would not have thought that if the judge knew these other things. So interested in what you guys say about that. And that's it for now. Thanks. Bye.